Major breaking news out of the United States Court of Appeals for the District of Columbia. A major court has just upheld in a 2-1 decision the District of Columbia's ban on magazines that hold more than 10 rounds. This case, however, will have implications, I believe, for the United States Supreme Court's decision whether or not to hear the Snope AR-15 ban case out of Maryland. Let's break down this decision in Hansen versus the District of Columbia when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on Israel Teach We Americans About the Right to Bear Arms. Check it out on Amazon. All right, today, folks, in the case of Hansen versus the District of Columbia, in a 2-1 decision, the District of Columbia Court of Appeals has upheld, if you will, the ban by the District of Columbia on so-called large capacity magazines, which are basically just magazines that hold more than 10 rounds. This law's been on the books going back over a decade, back to back, all the way back, in fact, when Judge Brett Kavanaugh was on the D.C. Court of Appeals. Now, this is particularly significant because the 3-judge panel consisted of Judge Douglas Ginsburg, who you may recall was nominated by Ronald Reagan to the U.S. Supreme Court, but then had to withdraw because he was smoking marijuana with his Harvard law students back in the day. So he had to drop out, and we got Judge Anthony Kennedy to become the Justice Anthony Kennedy. And it turns out, thank God we got rid of Doug Ginsburg, who has been terrible on guns in the D.C. Court of Appeals. So luckily, swapping out Ginsburg for Justice Kennedy in this particular instance was very good for the Second Amendment. The other judge was Patricia Millett. Judge Millett also ruled against the Second Amendment here with Douglas Ginsburg in this case involving magazine capacity bans. And Patricia Millett is actually been on the short list of the Obama, it's too late for her now, but she was repeatedly on the short list to be a United States Supreme Court Justice to be nominated by President Barack Obama. She never made it. So Judge Millett and Judge Ginsburg teamed up against Trump-nominated and confirmed Judge Justin Walker, who's done a very good job on the Court of Appeals for the D.C. Circuit, and I suspect will be on the short list as a potential Supreme Court justice if Donald Trump is elected president. So Judge Justin Walker wrote a very powerful dissent here. We're going to get into that in just one moment. But just to understand the lay of the land here, the plaintiffs in this case of Hansen versus the District of Columbia sued challenging the magazine limits by D.C. They sought a preliminary injunction. It was denied by the district court. They then asked the D.C. Court of Appeals for the preliminary injunction to be entered by the D.C. Court of Appeals. And in a 2-1 decision today, the D.C. Court of Appeals said no can do. No can do in a 2-1 decision against the Second Amendment. Now, let's break down this decision and go through some of the good and the bad and the ugly. Strangely enough, there's some positive things in this opinion. Now, let me give you the big picture before we break down the opinion. I think the fact that this decision was entered is actually helpful for the ultimate fight this year, which is to get the United States Supreme Court to hear the Snope case involving the semi-automatic rifle ban out of Maryland, which, as you know, is up on a petition for cert right now and is scheduled to be conferenced sometime in mid-December with a potential relisting for January and a possible cert grant of that Snope case sometime in January to be heard for oral argument later in the spring with a decision in June of 2025 if all goes according to plan and we get what we all are cheering for. Now, what's interesting here with this Hansen decision by the United States Court of Appeals for the D.C. Circuit, right, for the D.C., right there in the nation's capital, is this really just goes to show you're never going to have a circuit split, which often the Supreme Court looks for before they grant cert. Because all these anti-gun jurisdictions, the District of Columbia, New York, New Jersey, California, have an inordinate number of anti-gun judges who are going to rule against the Second Amendment most of the time. But it's very helpful here that we have this 2-1 decision because you have a very powerful dissent that really does track the language and law as set forth by Heller and by Judge Brett Kavanaugh, now Justice Brett Kavanaugh. And I should also note, and this is particularly important for you Four Boxes Diner viewers, Judge Justin Walker, in his dissent, explaining why he would have enjoined the magazine ban, meaning the magazines that hold more than 10 round ban. He would have enjoined it in part because he cites to Mark Smith, that's me, the Four Boxes Diner, and my article in the Harvard Journal of Law and Public Policy on some of the topics that we've talked about repeatedly on this channel, which is clearly correct, if you follow the law correctly. So it's good to see that Judge Walker was cited to and relying upon some of the scholarship that I put out in the Harvard Journal of Law and Public Policy on how to apply the in common use test, and how the fact is that when you're dealing with an arms ban case, the Heller decision is already the binding law. You don't have to make stuff up, which is exactly what the majority did largely here. But they didn't do a terrible job, strangely enough. They did a lot of good things, but they ultimately got to the wrong answer for all the wrong reasons. So we'll get to that in 1 second. So in short, let me give you the good news of this decision. What's quite interesting is that the two-judge, and we're going to talk about the majority opinion here now, because that was the court ruling, two to one. The opinion actually treats the in common use test as part of the text. Now, this is clearly wrong, but nevertheless, they still get to the right outcome by saying that magazines that hold more than 10 rounds are indeed arms under the text of the Second Amendment. But where this opinion really goes off the rails is they then go on and do the historical analog analysis, which was already done for them, by the way, in Heller. They just had to apply the Heller in common use test, and that's the end of it, which is what the dissent by Judge Walker said. But instead, the two-judge majority judges, in the majority opinion, went out there and tried to find analogical laws. And they ultimately said, and this is where my Harvard article is so important, they ultimately said what I had predicted judges like this would say, which is they claimed that these magazines that hold more than 10 rounds are somehow a form of unprecedented societal change or unprecedented societal development, as well as an unprecedented technological development, which is exactly what I predicted they were going to do, and exactly what I rebutted undeniably in my article, which I'll put a link to down below, which Judge Walker, in his dissent here, points out clearly. Because as you know, in 2007, you had a Virginia Tech shooting, unfortunately, where somebody used a semi-automatic handgun with magazines that held more than 10 rounds to kill many people at Virginia Tech in 2007. Then in 2008, you have the Heller decision that was well aware and litigated and considered the effects of the Virginia Tech shooting on the Second Amendment and found it had no bearing. So then when Bruin uses this language that says that, you can sometimes consider new analog laws, or you can consider sort of more broadly refined or broadly defined laws to justify modern gun control law, if you're dealing with an unprecedented societal change or an unprecedented technological change, the one thing we know for a fact that semi-automatic firearms with magazines that hold more than 10 rounds involved with a mass shooting are neither an unprecedented societal change nor an unprecedented technological change in the year of our Lord, 2024. And we know this as a matter of fact because a semi-automatic firearms were used with magazines that hold more than 10 rounds to commit a mass shooting in 2007 before the Supreme Court decided the standard in Heller of in common use, that you cannot ban any firearm in common use by Americans for lawful purposes. The focus is on how law-abiding Americans use the firearms, not how nutjob psychopathic terrorist criminals can misuse the firearms. But this 2-1 decision got it wrong. At least the majority of judges got it wrong. Judge Walker clearly got it right, which is why I think he has raised his level of the potential to be on the U.S. Supreme Court if Donald Trump is elected, which of course we all hope happens. So the two-judge majority here finds that magazines are indeed arms, which is correct as a matter of text. Then they go on and misanalyze the bond. They say that they then do the in common use test, which is part of history, right? Because the in common use test is derived from what? The in common use test is derived from history, specifically the history of being able to ban the carrying of dangerous and unusual weapons, which is all historical. Now, the reason why that's important here is the two-judge majority got this part wrong. Even though they reached the right conclusion, the way they got there was wrong. They said the in common use test derived from history was actually part of the textual analysis. But that's not correct. And we don't want that to be correct, because at the textual level, the Second Amendment plaintiffs arguably bear the burden to make the proper allegations. So we don't want, and it shouldn't be the case, that the in common use test, meaning is this arm in common use by Americans for lawful purposes, at the textual level, it has to occur at the historical level. And the reason why that's particularly important, of course, is at the historical level, the burden of proof to show that something is not in common use, the burden of proof to show that something is not typically used by Americans for lawful purposes or not in common use, is on the government. If you elevate that test to the textual level, you actually have shifted the burden to the Second Amendment plaintiffs to prove that a particular arm is in common use by Americans for lawful purposes, when the burden should be on the government at the historical level, because the in common use test derives itself from history and not from the text of the Second Amendment, which is an unqualified command, as the Supreme Court described it in Bruin. Nevertheless, this court did say that magazines that hold more than 10 rounds, which, by the way, amusingly, the two-judge majority of Judge Ginsburg and Judge Millett actually are calling these magazines that hold more than 10 rounds, ready for this, folks? Extra large capacity magazines. That's right. Extra large capacity magazines. They don't even say large capacity magazines. They call these extra large capacity magazines, like extra large eggs. Absurd, of course. This goes back to my point that a lot of these judges just have no idea about gun technology. Nevertheless, I think this two judges in the majority tried to get it right. They knew they wanted to rule against guns, but they tried to make it look as if they were following the methodology, and they sort of did it kind of, but ultimately they got it totally wrong. Why? Because rather than simply applying the Heller in common use test, which is the test set forth by the United States Supreme Court for whether or not you can ban a particular type of firearm, and if it's in common use, you cannot ban it, period, full stop. And there may be other reasons why, the way, you can't ban a firearm, by the way. There may be other reasons beyond the in common use test that we in the Second Amendment community can still win the case. But we don't need to worry about those other situations where we can still win, because when we're dealing with what we're dealing with today in 2024, semi-automatic handguns, semi-automatic rifles, magazines that hold more than 10 rounds, suppressors, these are no-brainers. These are clearly in common use. And if it's in common use by Americans for lawful purposes, it can't be banned. We don't have to worry about these other hypothetical things that could come down the pike. They're sufficient for us to win in common use. It's not necessary. There are other ways to win. But again, we don't need to belabor the point, because the in common use test is so favorable to us for the issues we're confronting right now. Now let's move on. So after the two-judge majority found that these magazines are arms, are in common use, they still allowed them to be banned by the District of Columbia. But what's interesting is they actually provide some helpful things for the gunfight going forward. Specifically, they literally guffawed at, they laughed at the Seventh Circuit Court of Appeals decision, and to some degree the Fourth Circuit, were trying to say that firearms that are most useful in military service are the ones that can be banned. But this is absurd. This court actually rejects essentially the big parts of the Fourth Circuit decision in Bianchi, now Snope, and the Bevis case out of the Seventh Circuit, by saying that the military versus non-military distinction is not relevant, which of course is correct. That is not a relevant distinction. The military versus non-military does not come up. The next thing, of course, they then talk about gunpowder storage laws. And I'm happy to report, as we've discussed on this channel before, gunpowder storage laws at the time of the founding have nothing to do with crime control. Gunpowder storage laws were a restriction on the storage of large quantities of black powder because it's highly flammable. It's highly flammable back then and highly flammable today. But this has nothing to do with the why. So you can't say that there was and the Supreme Court referenced this in the Heller decision, that says that black powder storage laws don't justify magazine capacity limitations, if you will, because they're not gun control laws. They're not firearms regulations. They are fire regulations. And thus the why they were enacted is totally different between preventing fires on the one hand versus preventing crime by bad people. So the why they were enacted makes these disanalogous laws and cannot be used. And that's what these two judges of the majority and all three judges really would agree with. Then we go on and they talk about trap guns, and they also reject trap guns as an analogous law, saying that trap guns, concealed carry restrictions, and laws regulating discharge are really just time, place, and manner restrictions. They're not about blanket bans. And keep in mind, as we've talked about before, that if you ban magazines that hold more than 10 rounds, what have you done? You have banned an entire category of firearm. Repeat after me. If you have banned magazines that hold more than 10 rounds, you have banned an entire category of firearm that can hold more than 10 rounds. Right? That's the key. That a magazine ban is not just a magazine ban, it's a category of firearm ban, i.e. firearms that are capable of firing more than 10 rounds without having to be manually reloaded. And that is exactly what is the case here with this District of Columbia law. And that is why it was right for the majority, the two judges in the majority, as well as, of course, the dissenting would agree with this, that trap gun regulations, concealed carry regulations, and laws regulating discharge at the time of the founding have nothing to do with a categorical ban on a type of firearm. That is correct. So to wrap up where they go, despite finding that magazines are arms, despite finding that magazines are in common use, which should have been the end of the inquiry, they go on and they appeal to that language from Bruin, as I predicted. A lot of the anti-gun judges would. That they said that, mass shootings using these kinds of magazines are unprecedented societal change or unprecedented societal developments and unprecedented technological change. And therefore, it's perfectly fine because of the enhanced lethality that these magazines offer mass shooters, they can be banned. But of course, this is wrong for a whole host of reasons. One, of course, is that if you look at the language about unprecedented societal change and unprecedented technological change in Bruin, it specifically excludes Heller. It says in cases other than Heller and other than Bruin, hear what I just said, other than Heller and other than Bruin, you may have to confront unprecedented technological change or unprecedented societal change. But Heller is the standard for dealing with gun ban cases. And this is a gun ban. It's an arms ban case. So you don't have to get into unprecedented anything you're not allowed to. And again, it's not true to say that a mass shooting with semi-automatic firearms with magazines that hold more than towns are unprecedented. Because it occurred in 2007 and before 2007, by the way. But we know it occurred in 2007 in the Virginia Tech shooting. And the reason why I keep hammering that home is because the Virginia Tech shooting was literally litigated and discussed in amicus briefs before the United States Supreme Court as the Supreme Court decided the Heller case, and despite that, issued the Heller decision that says if the arm is in common use by Americans for lawful purposes, it cannot be banned. So it cannot be unprecedented in the year of our Lord 2024 to have semi-automatic firearms with magazines that hold more than 10 rounds engaged in mass shootings. It cannot be unprecedented because it occurred in 2007 before even the Heller decision was decided. So it cannot be unprecedented by definition. It's absurd that these two judges, the majority, both of whom are shortlisters for the Supreme Court, one for President Reagan and, of course, one for President Obama, got this so wrong. Now, with this said, I think this helps us with the Snopes case because there's no doubt in my mind that the United States Supreme Court is going to be well aware of this case and they're going to understand what happened here and they're going to read it and they're going to read the dissent by Judge Walker, and they're going to think about this, and I think this enhances the likelihood of a grant of cert in the Snopes case, which, of course, other than the election of Donald Trump and the capturing of the United States Senate by the Republicans, the next mission-critical thing that the Second Amendment movement needs is the Supreme Court to grant cert in Snopes. That's what we want. That's the trifecta. There's obviously other things we want, but the election of Trump, a Senate controlled by the Republicans that can confirm judges, and the Supreme Court granting Snopes. And I think if the Supreme Court grants Snopes, which deals with the semi-automatic rifle ban out of Maryland, I am convinced that we have a 99% chance of winning that case if they grant cert. And they will find that you cannot ban categorically semi-automatic rifles, which would include the most popular rifle in America, AR-15s, AR-10s, and AK-47s, and the like. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. I'll put a link to my Harvard article that Judge Walker cites to several times in his dissenting opinion in this Hansen versus DC case. Don't forget to like this video and to subscribe, and feel free to share it with your friends. Don't forget to follow me on X at Four Boxes Diner, and we look forward to seeing you again soon here at the Four Boxes Diner.
Orders up. Table 2A.